Welcome to today's webinar. My name is Séamas Gray, and I'll be talking to you about preference claims under the Insolvency Act 1986. What I'll be looking at today is really key points for insolvency practitioners and advisors in both pursuing and also defending claims under the Act. It's a little weird for me because I can't see or hear any of you, so please forgive me if I proceed too quickly. However, the notes I've provided, the bullet points on the PowerPoint presentation, are pretty comprehensive, and I'm hoping that nobody will need to take too much in the way of notes. So the topics we'll be looking at, firstly, I'll be looking at the difference between a preference of fact and a voidable preference under the Insolvency Act. I'll be looking at what exactly is meant by the phrase influenced by a desire to prefer, and whether practitioners interpret this correctly. Further, we're looking at what motivating influences of a debtor in making the preferential payment in fact are acceptable so as to exclude such a payment from being considered a preference in law. Next, we'll have a look at the application, effect, and the evidential weight of the statutory presumption as it applies on a preference claim. And finally, we'll have a look at what key inquiries, documents, and other evidence both an advisor should really be looking at, or an insolvency practitioner who's thinking of pursuing a claim, which may influence the decision of the court. So starting with the Act itself, I refer to section 340, which is the bankruptcy equivalent, and 239, which is the liquidation equivalent. Throughout the presentation, you'll see I've put the relevant section numbers covering both bankruptcy and liquidation. The text that's before you now and later is the bankruptcy version of it. Quite simply, this is because it relates to the Rees decision of in Abdelali and Finnegan and another, which obviously I led together with Joe Curl of Nine Stone Buildings. So having a look at the section itself. Subject as follows. In this and the next two sections, where an individual is made bankrupt and he has at the relevant time, which is defined in section 341 and 240, which is the bankruptcy, the liquidation equivalent, given a preference to any person, the trustee of the bankrupt estate or the liquidator may apply to the court for an order under this section. The court shall, on such an application, make such order as it thinks fit for restoring the position to what it would have been if that individual had not given that preference. So you can see that the power of the court is very wide in terms of it can make an order as it thinks fit. But the order, one must remember as well, is restorative order. So these are going to the next two subsections. These are the two main bits for looking at what a preference is. For the purpose of this and the next two sections, an individual gives a preference if that person is one of the individual's creditors or a surety or guarantor for any of his debts or other liabilities. So the key bit there under subsection A is that the person who's being benefited by the preference has to firstly be a creditor, or they have to be a guarantor in respect of the debtor's liabilities. B, the individual does anything or suffers anything to be done which, in either case, has the effect of putting that person into a position which, in the event of the individual's bankruptcy, will be better than the position he would otherwise have been in if that thing had not been done. What's quite key there, I mean, effectively, we're just saying you're putting someone in a better position. But the words, and we did stress these in Abdelali as well, is in the event of the individual's bankruptcy. So the thing has to, when the preference is given, it has to be in the context that the person may become bankrupt or the company may go into liquidation. Now, even if that happens, under subsection 4, the court shall not make an order under this section in respect of a preference given to any person unless the individual who gave the preference was influenced in deciding to give it by a desire to produce in relation to that person the effect mentioned in subsection 3b above, the effect being putting them in a better position in the event of the individual, the company's bankruptcy or liquidation, respectively. And it's influenced by a desire to put the person in that position in the event of bankruptcy or liquidation. So the subjective desire has to have in contemplation bankruptcy or liquidation, and it's worth remembering that if you're able to show that the individual had no, or the company had no concept or belief that it would become that he would become bankrupt or the company would go into liquidation, you have potentially an argument that might defeat the desire to prefer. Subsection 5, an individual is given a preference to a person who, at the time of the preference was given, was an associate of his, otherwise than by reason only of his being an employee, is presumed, unless the contrary is shown, to have been influenced in deciding to give it by such desire as mentioned in subsection 4 above, i.e. influenced by a desire to prefer. And finally, it's worth just mentioning subsection 6, that the fact that something has been done in pursuance of the order of a court does not, without more, prevent the doing or suffering of that thing from constituting the giving of a preference. That would cover, for instance, the situation where an individual or a company is on the receiving end of a significant judgment in damages that effectively makes the individual or the company insolvent. And at that point, it's clear to all parties the individual or the company is insolvent. If they decide to just pay the judgment debtor and not other creditors, that can still be a preference. So looking at section 341 and 240, this is looking at the relevant time. This is looking at the statutory presumption. Subject as follows: a time at which an individual gives a preference is a relevant time if the preference is given in the case of a preference given to a person who is an associate of the individual, otherwise than by reason only of his being an employee, at a time in the period of 2 years ending with that day, being the petition presentation, the commencement of insolvency or liquidation. In any other case, it's 6 months ending with that day. So where you have an associate is defined under section 435, typically family members, but it's quite a wide definition, and it's always worth double checking when you're trying to ascertain whether or not the individual is an associate. You're looking at 2 years. And of course, that goes back to the previous section we referred to, in which if the person is an associate, not only do you have the benefit of the 2 years, but you also have the benefit of the statutory presumption. It's also worth mentioning subsection 2, and forgive me for not having put that on the slide, is the necessity that it's not a relevant time if the individual is not insolvent at that time. Insolvency must also be proved. What is a preference of fact? Typical examples of preferences include a payment of any one, it's typically one that's being challenged, but it can be more than one creditor is being paid, but clearly not all the creditors are being paid. So one or more creditors are being preferred to the other body of creditors. The payment of a debt that's been personally guaranteed. So the husband or the wife has personally guaranteed the liability of the debtor, and funnily enough, that debt is paid off whilst other debts remain unsatisfied. Another example that comes up quite frequently is where a party has been granted security in respect of its debt. So it will be fully secured, and once the asset is realised, they'll be paid in full, but of course the other creditors will not be paid. It's worth remembering that not all property will fall within the bankruptcy or the liquidation estate. And here we're looking at trust property or quis-close trusts. Trust property will fall outside. Quis-close trust as well, where money is advanced, for example, money is advanced to a debtor for a specific purpose. It's often considered to constitute a quis-close trust property, which is a type of constructive trust. We did raise that argument in Abdulali. I'm not going to go into all the facts and detail of that case. We did raise that argument, but it was unsuccessful for the simple reason that and the loan that had been advanced part of which was advanced by the second respondent, Reethy Limited, was advanced to the debtor. It was expressed on the terms of that loan, and they were documented, that it was understood that 200,000 of the 400,000 euros that was advanced were to be used to repay the first respondent, Mr. Finnegan. Because it simply stated that it was understood as a recital rather than an active term of the agreement, it wasn't a condition, and therefore it fell outside the parameters of quis close trust. So let's have a look at what the difference between a preference in fact and a preference in law is. Or you can make payments to people, and that's not necessarily going to be a voidable preference under the Act. In order to be a voidable preference under the Act, you'll remember the subsection we talked about before. It said a court shall not make an order unless, and it's this key part of this key subsection of the Act that is key in determining or differentiating between a preference in fact and a voidable preference. Here, the person must be influenced in deciding to give the preference by a desire to produce the preferential effect that was mentioned in the previous subsection. That is, putting that person into a position which, in the event of the individual's bankruptcy, will be better than the position he would have been in if that thing had not been done. What is important to remember is not to read words into the Act. It's very common. It's not common to use phrases like desire and influence by a desire, and people tend to fall into using more common words like intention, motive, purpose, aim, goal, objective, the reason, the basis, the grounds. And I will take you to some of the decisions on preference in a moment. The court has made it very clear that you're not to read words into the Act. One is simply supposed to read the word of the section. Is the person influenced by a desire to prefer? And in a short moment, we'll go into some further detail on the types of motivating desires, or shall I say influencing desires. In MC Bacon, this is obviously the key decision from some nearly 30 years ago. Millett J, as he then was, emphatically protested against this practice. And then this passage of his judgment is very informative as to the difference between the word desire and other common words that are commonly used in substitution for the word desire, but actually have an entirely different meaning, including words such as intention and motive. A man is taken to intend the necessary consequences of his actions, so that an intention to grant a security to a creditor necessarily involves an intention to prefer that creditor in the event of insolvency. Desire is a very different matter. Intention is objective, desire is subjective. It is not, however, sufficient to establish a desire to make the payment or grant security, which it is sought to avoid. A man is not taken as desiring all the consequences of his actions. Some consequences may be of advantage to him and be desired by him. Others may not affect him and be matters of indifference to him, while still others may be positively disadvantageous to him and not be desired by him, but be regarded by him as the unavoidable price of obtaining the desired advantages. In Ledingham Smith, which is another significant decision on preference that is worth having a read if you've not yet had an opportunity to do so, Justice Morris there made clear there is no basis for any gloss on the statutory words influence and desire. The court should not attempt to further define the words desire and influence. Rather, the court should consider all the evidence and apply the test using the words in the statute to the court's findings of fact. There is a common misconception in preference claims that insolvency practitioners and advisors look to, which is what was the reason? Well, people tend to say things like, "What was the reason? Why did he make that payment?" What was the correct question? Obviously, should be what was his desire in making that payment? But what was his desire? Was it? And this comes from Justice Miller's decision in MC Bacon. There's a passage where he comments, "It will still be possible to provide assistance to a company in financial difficulties, provided that the company is only actuated by proper commercial considerations." From that, it's often been argued that this section, or this section 340 on preference, it should be 239 though, my apologies for liquidation, can only operate to relieve a counterparty from the effect of a preference where there is good reason for it. So a lot of advisors have proceeded on the basis that unless the respondent, if you're acting for an insolvency, an office holder, unless the respondent can show that the payment was made for good reason, that it must therefore be a preference. That isn't quite correct. Contrary to common belief, there's no fetter on the range of acceptable desires that the court may find to influence a debtor's decision to make a payment or grant security, or indeed some other preferential effect. In Abdel-Ali, this argument was certainly run by the trustee that there had to be a good reason for it, and we took the court, both first instance and on appeal, to various examples of what were considered acceptable desires. In MC Bacon, the court looked at the desire was to avoid the bank calling in an overdraft and to continue trading. Again, in MC Bacon, there was the misapprehension that a debenture would not be valid unless the company continued to trade for 6 months after it was given. Obviously, misreading or misunderstanding Section 245 of the Insolvency Act. So that granting a debenture would ensure that the bank would continue to support the company for a further 6 months. In Re Fairway magazines, there was the need to raise money to keep a business running and maintain credibility while negotiations for the sale of a profitable part of the business were in progress. Again, in Re Fairway magazines, and this was a phrase counsel used throughout our hearings, to alleviate cash flow difficulties and keep the wheels on the wagon. In Leddingham Smith, to ensure the continued provision of services by an accountant necessary to continue as a going concern so that a business could be sold. In Rooney and Das, we even have a situation where the debtor was receiving written and oral threats of litigation, and he made a payment in response to those, and that was considered to be the desire that was considered to be what influenced his desire to make the payment, rather than a desire to put the recipient in a better position than he would otherwise be in the event of the debtor's bankruptcy. To stop creditors hassling the debtor. In Re Oxford Pharmaceuticals, to regularize the position with the bank, and also to stabilize the position of two companies. So there are lots of acceptable desires. It's also important to note that it's actually not necessary to show any desire, and I will come to that in just a moment. On appeal, in Abdel-Ali, Justice Burst gave the argument that you have to have a good reason for making the payment as being based on a fallacy. So that entire argument and line of argument that's been pursued by many a trustee and liquidator over the years has been completely dismissed now and being clarified by the court as being based on a fallacy. That is simply, he continued, that is simply not what the words of the section say. The legislation is structured the other way round. To be a voidable preference under the section, a particular improper desire must have been influential on the debtor. It is the presence and influence of that improper desire which means the preference falls into section 340 subsection 4 and becomes voidable, rather than the absence of a proper desire. It's also, as I just mentioned, it's not necessary to actually show what the desire of the debtor was in making the payment. What is necessary is to show that the debtor had the necessary improper desire. That can be quite important to be aware of, although it's worth saying as well that if one is not able to show what the desire of the debtor was, then it's going to be more difficult to show that he didn't hold the improper desire, and that's obviously even more important where we have the statutory presumption, which I'm going to come to in a moment. But it's certainly, that was an argument we raised in Abdul Ali, and the court accepted it, although in Abdul Ali it was quite easy to ascertain what the desire of the debtor was, and the court found actually he had several desires, but none of them were the improper one. It's more difficult, obviously, to show that he didn't have the improper desire if you're unable to show what his desire was. If that sounds like it's going to make life difficult to pursue a preference claim, the comments on the slide in front of you should hopefully provide some comfort for advisors and insolvency practitioners. As Justice Burse confirmed in Abdul Ali, approving the decision of District Judge Salmon at first instance, as he then was, he's now a circuit judge, I understand. If more than one factor was influential in the debtor's mind, it is sufficient if just one of the factors which had influenced them had been to put one of the unsecured creditors in a better position. If that factor was present, i.e. meaning influential, it does not have to be the decisive factor which caused the debtor to do what they did, nor does the trustee have to prove that it was the factor which tipped the scales in favour of making the preference. Previously, people used to consider that you had to show it was the main desire or the most significant desire, or the phrase you see there, having tipped the scales in favour of making the preference. It doesn't have to be any of them, provided you can have 12 different factors that might have influenced your desire. If just one of them, if just one of those factors, one of those desires rather, that are influencing you are to put the recipient in a better position than he would otherwise be in the event of his bankruptcy, then the claim should succeed. Now, of course, this is really looking at these claims from an office holder perspective. And it's often very, very difficult for insolvency practitioners. One of the key practical features that separates insolvency litigation, unfortunately, from most other legal disputes is the fact that the party bringing the claim, the office holder, is usually, unfortunately, completely unable to give any first-hand evidence of the background facts. By the time the office holder turns up on the scene, the relevant events giving rise to the claim have usually already happened, and sometimes that can be several years previously. The office holder often faces a significant disadvantage. He needs to prove matters to which he was not a party in circumstances where the actual protagonists often have reason to put a self-serving spin on the facts. That makes life very, very difficult. And that is particularly so where you're having to try and show a subjective desire on the part of the debtor. To even things up a bit, the legislature has bestowed on insolvency practitioners the benefit of a statutory presumption, with some claims available under the Act, requiring a respondent to then disprove rather than for the office holder to prove. An example, obviously, is transactions at an undervalue, where the insolvency of the debtor is presumed unless the debtor is able to show otherwise. And on preference claims, which is extremely helpful, the transferee debtor's state of mind. This is the subjective desire. Was the debtor influenced by a desire to prefer? Without the benefit of the statutory presumption, it would be very, very difficult for office holders to pursue these claims at all. And if one doesn't have the benefit of the presumption, well, you don't actually see too many claims pursued, because it is so difficult to show that a debtor actively intended, or rather had the necessary desire to prefer. It is a very subtle and sometimes difficult inquiry. This goes back, of course, to I'm reading back to section 340. The court shall not make an order under this section respective of preference given to any person unless the individual who gave the preference was influenced and decided to give it by a desire to produce in relation to that person the effect mentioned in subsection 3b above, being to put him in a better position than he would otherwise be in the event of his bankruptcy. An individual is given a preference to a person who, at the time the preference was given, was an associate of his, otherwise than by reason of his being an employee, is presumed, unless the contrary is shown, to have been influenced in deciding to give it by such a desire as is mentioned in subsection 4. And subsection 4 sits above, so you can see that. However, the statutory presumption is not an absolute panacea. It's useful, as we said, because trying to ascertain whether someone was influenced by a desire to prefer is not an objective test, it's a subjective one, and one has to look at the debtor's state of mind. That's extremely difficult to prove from an office holder's perspective. So to have the benefit of the statutory presumption overcomes that initial difficulty, but it is only an initial difficulty. It must be remembered that the burden of proof in litigation is very seldom decisive in of itself. All we're simply talking about here is the burden of proof. This is not increasing the burden of proof to some form of sort of fraud level. This is simply saying who has to prove that one simple fact. So the debtor has to simply here show that that wasn't his desire. It doesn't really, for a trustee or a liquidator to just sit on the desire and not put forward any other positive case will make his position very, very difficult. It's definitely not advisable for office holders to sit on the benefit of the statutory presumption, assert the claim, and effectively leave it to the defendant to prove his or her case, which is what happened in Abdul Ali and Finnegan. In fact, the trustee admitted he put forward no positive case on that at all. It was made extremely difficult on that case because, sadly, the debtor, this is one of the reasons why he filed for his own bankruptcy, and in fact he filed for his own bankruptcy a few weeks before the end of the 2-year period, in which case there would have been no claim at all. He wasn't well. He got cancer and he subsequently died. The trustee did not even interview him when he had an opportunity to do so, and he said, "Look, I'm still able to help and can answer questions." So he didn't put forward any positive case at all. That, of course, didn't make life any easier for the respondents in this case, because they also didn't have the benefit of the debtor giving evidence to say, "No, that wasn't my intention." Although as most office holders listening to this webinar or advisors who assist insolvency practitioners will concur, my experience when pursuing preference claims for office holders is that if the debtor is around, his comments are often very self-serving. However, and the comment at the bottom is I accept that there are often very limited funds available to a trustee or a liquidator, and that is going to affect what investigations a trustee or liquidator might be able to undertake. And it will obviously be, if to the extent there are lots of funds, one can pursue lots of different investigations to try and prove one's case. But when there are limited funds, it is very tempting to simply rely on the benefit of statutory presumption if it exists. But when we continue this presentation, I will take you to some key investigations that it should be possible for an office holder to undertake, even where there are limited funds available, which will greatly assist a court in finding in favour of the office holder if he brings the information together, and obviously from a debtor's perspective, what information he or she should be trying to put before the court which may influence his decision. So, having looked at the statutory framework, how does the court approach this? Well, this has been set out on a number of occasions. In MC Bacon, the court set this out in Ledingham Smith, the court set this out in Abdul Ali, the court confirmed this is exactly how a court will look at every single preference claim. One first simply needs to look at what is the transaction complained of. What exactly we're talking about here. If it's trust property or otherwise, it's not going to be in there. Is the person a creditor or surety? One has to look at the transaction being complained of. Was that transaction made within the relevant time? As we all know, there are limitation periods within or after which it's not possible to challenge certain transactions. So if it's over 6 months, then one's going to need the other party to have been an associate in order to come within the relevant time. And even then, one is still only looking at a period of 2 years. So 6 months or 2 years. If it's before then, unfortunately, one will have to look at another method of challenging it, whether under section 423 as a transaction defrauding creditors or otherwise. Does the transaction amount to a preference as defined in section 340 subsection 3 or section 239 subsection 3 in the case of liquidation? This is going back to what we talked about earlier. Is this a preference of fact? And obviously, so we're looking again at is the party who's been preferred a surety or guarantor, or are they a creditor? Has security been granted to the creditor? Has a liability been paid off that was guaranteed by that person? Is there trust property there? Does that take it out? Is there a quis close trust? Does that remove it from being a preference of fact? So those arguments are all relevant. If the transaction amounts to a preference of fact, was the bankrupt or company in giving the preference influenced in deciding to give it by a desire to produce the effect of putting the recipient in a better position, which in the event of the debtor's bankruptcy or liquidation, he would be better than it otherwise would have been. But that's taking the preference of fact to avoidable preference under the Act. And then it's worth looking at, does the statutory presumption apply? And if so, has the contrary been shown? The burden of proof, as I said, there are lots of things that have to be established in any preference claim, including the preference of fact we've talked about, the influence by desire, insolvency as well. I should say that in Abdul Ali, the fact that Mr. Finnegan, who was the husband, the debtor was his brother-in-law, his sister's husband. We accepted that he was an associate. We also accepted that he was insolvent at the relevant time. So those arguments did not come up. But insolvency can be a very difficult one to argue. And the statutory presumption, so there are lots of things one has to argue and prove. And but as I'm sure everyone listening will appreciate, the arguments can be put forward on both sides. the court's simply going to decide on the balance of probabilities what is correct. And that really applies to all matters that have to be proven or disproven, as the case may be, in terms of the statutory presumption. As I said earlier, the benefit of the statutory presumption is seldom, or the burden of proof is seldom in and of itself decisive. So it's advisable to try and put forward a positive case and evidence in that regard. It's also worth remembering that even if you prove everything, if you've done all of that, and you've proved there's a preference of fact, you've proved it's avoidable preference under the law, you've done everything, the court's power to make an order is still very wide. The court can make such order as it thinks fit. It's not required to make an order. As Paramount Airways showed, one has to remember that even if all these criteria are made out, an order under Section 340 or 239, mistake keeps coming up, my apologies, the court still holds a residual discretion as to whether to make an order. So it's not an absolute even then. For the purposes of today, I'm not going into the criteria that a court would look at under Paramount Airways. It applies to various parts of the Act, but because it's a discretionary order, it's not an absolute certainty in any case. Right, so looking next, and it's worth mentioning now, this is what you want to do at the beginning of the litigation. There is no point issuing proceedings with the benefit of a statutory presumption or otherwise and find yourself halfway through very expensive litigation without a case. I would say this was a mistake that occurred on Abdul Ali, not that they considered that they had made a mistake on the case, but they hadn't obtained a lot of the information which would usefully have assisted the court and their own argument, or I would say even more importantly than that, would usefully have informed their decision to issue proceedings in the first place. And had they obtained much of this information in advance, then they might have determined that it was not worth pursuing this claim and that they would fail and would have saved a lot of money. The most obvious here is to speak to the debtor. I fully appreciate that the debtor can be entirely self-serving, but his interview and the interview notes are extremely important. What was quite incredible on Abdul Ali is they had interviewed the debtor many moons before, but had never actually put this to him. When they say they established when they say that they established that this was a preference claim, they still didn't bring the debtor in and actually ask him about it, even though he had said he was willing to assist. That is very, very helpful. What's useful from a claimant's perspective in getting those notes, even though the debtor may well be self-serving, is to undermine the debtor's credibility in terms of his excuses for having made the payment. If what he says in his interview, and you've got interview notes to show otherwise, it can be very, very useful evidence in undermining the credibility of the debtor in the witness box, whose evidence will otherwise potentially be accepted by the court as it is said. So that is one of the most useful bits, is just making sure you have those interview notes. Obviously, one has to speak to the respondent. They can have very useful information that will inform and assist in narrowing additional investigations. In the most recent case in Abdul Ali, the respondent, our client in this case, we could provide copies of the first loan agreement. Going into the facts of that very briefly, there was an initial loan to the debtor of €200,000 to assist him in paying his liabilities. The debtor had sold sold his business to Liberty for something like £20 million just before the financial crash. He'd invested the money in lots of different properties and otherwise, which had obviously all gone south when the bottom fell out of the property market in 2008. There were some warranty claims in the sale to Liberty that he was liable for. So he was stuck with a liability of about 2.3 million euros. Sorry, I keep saying euros. The respondents in this case were both an Irish company and an Irish individual, and the debtor was also Irish, although he was made bankrupt here because he was working in the UK at that time. We were able to provide a copy of a very short form loan agreement, as it were, which is more of a letter in which the respondent was required to pay the money back within 5 weeks, but he didn't do so. Additional information was provided to show that when he didn't pay back the money, the respondent applied pressure on him to do so, and there was talk of securing the loan over property, an unencumbered property in Mallorca. Unfortunately, he then became liable to his co-directors in relation to those warranties, and he needed more money. This is where he asked for a further 200,000 euros, which the respondent was unable to, or reluctant to provide, because he also had his own financial difficulties at that time, bearing in mind the financial crash in 2008. He did have money in one of his companies, which he could loan from this was Rethi Limited. So he agreed he would loan 400,000, but that was on the basis the 200,000 euros was paid back. And that was obviously ultimately the challenge transaction. But lots of information was provided that informed the trustee as to the circumstances. In light of the information that was provided, I'm surprised that the trustee chose to continue to pursue the proceedings. I believe he did so simply because he had the benefit of that statutory presumption, which, as we've discussed earlier, is no panacea. He had also accepted that in Abdul Ali, the requirement or the reference in the second loan, the Rethi loan, that it was understood that he would use that to repay the Finnegan loan, the first loan. He accepted that was a condition of the second loan, but at trial, which is why the quis closed trust came up, but at trial they argued that was not the case, and actually they were correct and succeeded on that point. So what further documentation? So then speaking to the debtor and speaking to the respondent, those are relatively easy things to do. The debtor you're going to be interviewing anyway if you're the office holder, and that's something you're required to do. So in terms of in funds available in the litigation to actually pursue this, you're definitely going to be interviewing the debtor. You're probably not going to be interviewing the respondent, but as he's the respondent to the claim, you will be communicating with them and asking them and challenging the basis of the payment. So he will be coming out with various reasons that, if they're not consistent, are likely again to undermine his or her credibility. The respondent, if the position of the respondent is changing, then when it comes to a hearing, again, their evidence can be undermined. It's very, very important because first-hand witness evidence, people often forget, is very difficult to overturn unless you're effectively calling the witness a liar. And unless you've got very, very strong evidence indeed to suggest that they're not telling the truth, that is very inadvisable, and the court does not like that. So what is useful is the correspondence you have with them. If you do meet with them, then by all means have a detailed note taken. And if their position changes as to the basis upon which they apply pressure or otherwise to get the payment, then that will undermine their credibility in the witness box. Of course, there are other documents, statutory documents that will be obtained at the outset, the questionnaire, and the statement of affairs. What was said about the payment in each of these documents? Again, this all comes down to consistency. If there is a lack of consistency or the story changes, the credibility of that witness in the witness box, whether that's the debtor or the respondent, is going to be undermined. And if you're trying to overturn what is first-hand evidence from the debtor or the respondent in court, you're going to need some documentation with which to do so. And these are key documents that the office holder will have and or should prepare in the case of interview notes, and should take care in producing those. What else? Bank statements. These are key. In Abdulali, we had a few that were provided by the trustee, but there were lots of bank accounts and payments having been made. And we said, well, look, that he was trying to, the debtor in this case was definitely trying to keep the wheels on the wagon, so to speak. And in fact, there was a conversation, because the property market actually came good in Ireland, that if he'd actually been able to continue for a little bit longer, all of his payments, he would have been able to pay all of his creditors. But he certainly wished to try and keep all of his creditors at bay, and he nearly succeeded for nearly 5 years in keeping them all at bay and actually moving things forward. But what we were seeking here, we said, well, look at the bank statements, see who he's trying to pay, and see whether this consists of a preference in our favour. Because the money that was lent by Mr. Finnegan went straight to Friends First. It was, it was clear that the money he was borrowing, robbing Peter to pay Paul, so to speak. And as Mr. Finnegan said in the witness box, he said, well, if he was robbing Peter to pay Paul, I was Peter, not Paul. So it's worth having a look at the bank statements. One also has to remember here that it's the trustee or liquidator who can provide those bank statements. Obviously, the debtor would be able to provide those bank statements if he was alive. In our case, he wasn't. So we had no ability to get the bank statements. We could have obviously chased his widow, but that wasn't considered entirely appropriate or sensitive at the time. So we chased the trustee in this case to obtain them. He refused to do so. He issued proceedings, and it was only in the months before, and well, in fact, in a couple of cases on a couple of the accounts, it was only in the weeks before trial that the bank statements, on advice of his counsel, no doubt, were actually ultimately provided. We produced from the bank statements schedules. We had a de minimis rule, and we went through his bank statements over the entirety of this sort of 5-year period we're talking about. Well, the initial loan was 2009, second loan was 2011, and then you had his bankruptcy in 2013. So we looked at the relevant time, both back in 2009, but also around 2011 when the challenged transaction occurred. And we produced a schedule showing these were payments of in excess of 1,000 or 5,000 euros, I forget, who he was paying exactly. And we could show that he was paying his accountants, he was paying various people to try and his solicitors in relation to the litigation he had with his fellow directors. He was trying to keep the wheels on the wagon, and the court was satisfied with the evidence that it saw. But the court actually applied some, I think, well, I don't want to say considerable weight, but the court was certainly very interested in the schedules and looked at the payments, and they did influence the decision of the court. Obviously, there's also emails and letters or other correspondence with the preferred party if one is able to get hold of that. Obviously, in terms of a company, you'd like it to have a considerable amount of emails. With an individual, it's more difficult. But having a look at, we were able, certainly in Abdulali, to show correspondence where payment was being chased. I have to say, because it was a family relationship, there weren't any threats of litigation or threats to petition or similar, but often one will find those. And as I mentioned earlier, in terms of acceptable influencing desires, in Rooney and Das, one of the desire there was to stop creditors hassling the debtor, and also following written and oral threats of litigation. So if somebody is threatening to issue proceedings or petition and a payment's made, it's often possible to show that that party was not being preferred. There was no desire to prefer that party. It was simply as a reaction to pressure being applied. And if one identifies significant creditor, that's beneficiary pressure to pay, I would be very cautious about issuing a preference claim in those circumstances, because that suggests otherwise. That really takes us towards the end of the proceedings. If there are any further questions, you're more than welcome to use my mobile, not right now, of course, or my email, and I'm happy to look at those. I will just conclude with this statement. I mentioned to you before that on Abdul Ali, I mentioned to you before that generally, it isn't necessary to show what actually activated the desire of the debtor in making the payment or doing the thing that the debtor did. But it's obviously helpful to do so because it gives a court a motivating, rather an influencing desire to look at, rather than simply to decide on the basis of the statutory presumption, which is that he must have had the desire to prefer. As District Judge Séamas, as he then was concluded in the first instance, the lending was in part to pay creditors, in part to keep the ship afloat, in part to hope that business ventures would come good. I'm satisfied that he was motivated by that desire rather than the desire to prefer Mr. Finnegan as against other unsecured creditors. I'm satisfied on the balance of probabilities that he, the debtor, was not influenced when he paid those monies by a desire to produce the effect that the result of his bankruptcy would put Mr. Finnegan in a better position than he would otherwise have been. I've reminded myself that the requisite desire to influence a decision need not be the sole desire, and there may be other factors that influence a decision that do not include the requisite desire. However, the requisite desire must have been one of the factors that operated on the mind of the debtor. In fact, I'll read you one more paragraph that he stated right at the end. For the avoidance of doubt, my finding of fact is that the debtor was insolvent, and therefore, of course, it would have been possible potentially for any creditor to sort his bankruptcy at any moment in time, but he'd been able to keep his creditors at bay. He anticipated that his income and finances, including property values, would come right, and that everybody would be paid, and that the insolvency would not be the inevitable cause. I came to the view that he had no desire to prefer as set out in the evidence. And this is why I highlighted at the beginning of the presentation the reference to in the event of insolvent liquidation or in the event of their bankruptcy, because that has to be somewhere in the mind of the debtor. So it's not just about preferring someone, making a payment that they receive something. So this influence by desire reference that people refer to, it's not just about putting someone in a better position than they are. It's about putting someone in a better position than they would otherwise be in the event of bankruptcy or liquidation. And that needs to be there too. On that note, I have come to the end. Please feel free to contact us directly, or as I said before, you have my email address and you have my mobile number. Thank you very much.